Start. The case of the respondent is that the land in dispute was donated by Kunwar Shivendra Bahadur Singh in favor of Bhudan Committee in the year 1957. The committee was therefore required to have distributed this land in favor of landless agricultural laborers within 3 years as provided under subsection 2 of the Act 1939. According to the respondents, they were distributed the land by the Bhudan Committee in the year 1978, considering the provisions of subsection 2 of section 14 of the Act 1939. The Bhudan Committee did not have power to distribute the land amongst the respondents in the 1978, and it was the collector who could have distributed the land if there was no notification issued under section 4 of the Act 1927 to constitute the land. If there was no notification issued under section 4 of the Act 97 to constitute the land as reserved forest. It is important to take note of the fact that the Bhudan Committee never filed any objection to the notification issued under section 4 of the Act 1927 in respect of the land in question. The respondents, after they got their names mutated in the year 1978, came before the Forest Settlement Officer and filed objections in the year 1979. Once it is held that the Bhudan Committee did not have any right, title or interest over the land when allegedly the patta lease were granted in favor of the respondents, and their objections could not have been entertained. The respondents, on the basis of the alleged patta lease in their favor, did not become the Bhumidhars, and even if it is assumed that the patta lease, though no such patta lease has been produced by them, was valid on the basis of which their names got mutated in the revenue record, they become only tenure holders, and the proprietary rights in the lands vested in the state. The Supreme Court in 1996, 5 SCC 194, State of UP versus Deputy Director of Consolidation and others, has held that a person who was holding the land as Sirdar was not vested with proprietary rights under the Act 1950. He was a tenure holder, and the proprietary rights vested with the state. Paragraphs 6, 7 and 8 of the State of UP versus Deputy Director of Consolidation and others, supra, which are relevant, are extracted hereunder. This court in Mahendralal versus State of UP dealt with an identical question. Mahendralal, in a petition under Article 32 of the Constitution of India, contended before this court that he, being a Bhumidhar in possession, the provisions of the Forest Act 1927 would not apply to the said land. Repealing the contention, this court held that though Bhumidhars have higher rights than Sirdars and Assamese, they were still tenure holders under the state, which was proprietor of the land in the areas to which the Abolition Act applied. It was further held that even if it was presumed that the petitioner Mahendralal was a Bhumidhar, he could not claim to be the proprietor of the land. It was held that the provisions of the Act would be applicable to the land in dispute. It would be useful to reproduce the relevant part of the judgment of this court in Mahendralal's case. It is, however, urged on behalf of the petitioner that he claims to be the proprietor of this land as a Bhumidhar because of certain provisions in the Act. There was no such proprietary rights as Bhumidhar right before the Abolition Act. The Abolition Act did away with all proprietary rights in the area to which it applied and created three classes of tenure by section 129 Bhumidhar, Sirdar and Asami which were unknown before. Thus, Bhumidhar, Sirdar, and Asami are all tenure holders under the Abolition Act and they hold their tenure under the state in which the proprietary right vested under Section 6. It is true that Bhumidhars have certain wider rights in their tenures as compared to Sirdars. Similarly, Sirdars have wider rights as compared to Asamis. But nonetheless, all the three are mere tenure holders with varying rights under the state, which is the proprietor of the entire land in the state to which the Abolition Act applied. Over.